Good evening, friends. After, I would say, a lot of time, Mr. Srinivasa has agreed to share his knowledge, though we had been requesting him, but due to certain personal issues, he couldn't share his knowledge. And that's why when he came back, they say that good people come out with actually a bang. To speak on a particular topic is always a challenge. But once you speak on the interplay of different aspects of law, it only speaks volume of that person's caliber to decipher and structure his thoughts so that everybody can understand. And today's legal journey of understanding is on interplay of law, alienation of trust properties, and we need not reintroduce Mr. Raghavan, and we are too glad that he has acceded. His volumes of knowledge also reflects from the fact that he has taken us through various different spectrums of law. I will not take much time since it's a festive season, and while we hear Mr. Raghavan, we are not caught with the trappings of Ravana that we have caught hold during the festive season, everyone. Over to you, Mr. Raghavan.
Thank you, Mr. Vikas. Happy to be in the forum for a long time. For some personal reason, as you said, I could not come on this platform. I'm happy to be back again now. See, coming to the topic straight, without wasting much of the time, I have been harping on this topic for long before various courts and forums. See, the trust in India can be broadly categorized into two major types: public trust and private trust. We all know. As regards the public trust and private trust, we have something in common called religious trust. A religious trust can either be public or it can be called as a private trust also. There are some religious private trust also. So we have to conveniently categorize them into three broad categories: public charitable trust, private or public religious trust, and private charitable trust, for better appreciation of the law governing the field. So we have got 4 different enactments in the least to govern the issue of right of the trustees to alienate the trust properties, irrespective of the nature of trust, public or private, religious or charitable. So the foremost thing to be considered by us is whether leave or permission of the court is compulsory or mandatory to alienate or dispose of trust properties. This has been in the limelight for a long time, though there are a lot of judgments either way. But I am of the firm opinion, drawing strength from judgment of Supreme Court in the year 1969 onwards, that if the trust deed contains a recital, or if the trust deed permits the trustees to encumber the trust properties, of course, it goes without saying, for the welfare of the trust or for the interest of the trust, we may very boldly say that the trustees can encumber or alienate the trust properties. There are some exceptions regarding religious trusts are concerned. I'll come to it a little bit later. But by and large, the general law of the land is very clear that if the trust deed permits the trustees, if the trust deed contains a recital permitting the trustees to do so, there is nothing wrong on the part of the trustees to encumber, alienate, or dispose of the trust properties, subject to a rider that it is done in the interest of the activities of the trust or for the welfare of the trust. Okay, now what happens to such an alienation done by the trustees without the leave of the court? This is the million-dollar question. There are occasions where the purchasers or lessees who are approached by the trustees for alienation or disposal or even lease of the trust properties, coming to an advocate for an opinion on the title deed. Or if a trust property is sought to be mortgaged, the financial institution and banks may ask for an opinion of the panel advocate. So we can't be sure of the fate of such alienation. in the absence of a specific sanction by the court of law. Here lies the lecture of the day. So I would like to first speak about the provisions which are governing the field for various types of the trust. As I said earlier, there are public trust and private trust. If we categorize religious trust into a special category, we can segregate such religious trust into a separate subcategory. So we have to first venture into public charitable trust, leave alone the public religious trust. Many of the people are of the opinion that there is only one enactment or there is only one provision of law governing the field when it comes to public charitable trust, namely Section 92 of the Code of Civil Procedure. Surprisingly, there is one more enactment which is seldom noticed or seldom applied. We have a central enactment as early in the year 1920 that is called the Charitable and Religious Trust Act 1920. A very small enactment that has got only 12 sections, in which section 7 is very much relevant. So before going into the niceties of the distinction between section 92 of CPC and section 7 of the Charitable and Religious Trust Act 1920, we have to just travel into the scope of section 92 CPC first. As we all know very well that the Indian Trust Act 1882 applies only for private trust. So the derivation is very clear that in India, there is no enactment for public trust by the central government. We all know that respective state governments, some of the state governments in India have enacted a special law for public trust for the particular state is concerned. For example, Maharashtra, Gujarat, etc. Even in Tamil Nadu, in the year 2020, an act was enacted and it was notified in the Gazette. Act 41 of 2020, called the Tamil Nadu Public Trust Act. But for the reasons best known to the lawmakers, the act, even after notification, was withdrawn by the state legislative assembly. Subsequently, the new government that was elected also came out with a bill. But once again, for the reasons not made known public, the bill was not pushed into and it was not made into an act of the legislation. So in Tamil Nadu, there are no state laws for public trust. A few state governments have got laws. So we have got two sets of laws where there are state laws and the CPC on one hand, and two sets of laws where there are no state laws, namely the Charitable and Religious Trust Act 1920 alongside Section 92 CPC. We all know Section 92 CPC is very elaborately dealing with the affairs of the public trust. This provision enables two or more persons, either with the leave of the court on application or by the Advocate General himself, after having been satisfied that there needs an occasion in which the adjudication of the civil court is sought for. Friends, please bear in your mind that the jurisdiction under Section 92 CPC is basically not advisory. It is not consultative. It is rather adversarial. So, the first and foremost piece of legislation that governs an affairs of the public trust, to be precise, public charitable trust, is Section 92 CPC. Now, we'll just shift our attention for the time being to Section 7 of the Charitable and Religious Trust Act 1920. A person who has got a rough idea about Section 34 of the Indian Trust Act 1882 may find that Section 7 is similarly worded, not exactly the same, similarly worded. What is very important to know is that Section 92 CPC is adversarial. It is not advisory. It is not consultative. And the judgment of the civil court rendered under Section 92 CPC is binding, and it is an appealable decree. It is a suit in all aspects of the litigation. Whereas Section 7 of the Charitable and Religious Trust Act 1920 is only an advisory provision, a consultative provision, where the trustees seek the opinion of the court. Friends, please bear in your mind that when I speak of court under Section 7 of the Charitable and Religious Trust Act 1920, it means only the principal court of civil jurisdiction of the district concerned. That means the district judge. I am of the firm opinion that it can be only the principal district judge unless the state government has delegated the power to the additional district judges. But in case of 92 CPC, there are notifications by the respective state governments because CPC permits state amendment. In Tamil Nadu, it is either the subordinate judges court or the district judges court, depending upon the pecuniary jurisdiction of the dispute concerned. So, an interesting question comes into mind when we invoke Section 92 of CPC. Friends, you know very well that this kind of sessions are academic in nature, and we are not here just to give a ready-made solution for all the points to ponder. At times, the law remains dubious. At times, the law remains debatable. At times, the law remains rather chaotic, to be frank. So now I just want to pose some interesting propositions to you that at the end of this session, you may have a perspective of what the law is about, but the ultimate solution depends upon each and every fact of the case and the knowledge and experience of the advocate as well as the judicial officers. If you go through Section 92 CPC with a cursory appreciation, it speaks of two contemplation or two contingency, namely, when there is a breach of trust, that is, a violation of the objectives or the terms and conditions or the conduct of the trustees. The word used by the legislation is breach of trust. Or when the court wants to interfere in the administration or management of the trustee. These two contingencies are contemplated. Here, two important questions come up for a consideration. Section 92 CPC does not speak a suit by the trustees. It speaks of a suit by two or more persons. It need not, it has not, or it does not speak of a suit by a trustee against another trustee. This is one of the points for introspection. Of course, there are judicial pronouncements that permit a suit by a trustee. But I just want to pinpoint one thing. Section 92 CPC does not contemplate a suit between trustees. That is to say that a trustee as a plaintiff and another trustee as the defendant. It primarily speaks of a suit by two or more persons. Who can be the two or more persons? Any beneficiary of the trust, or any person interested in the trust, or any person who has got a concern over the activities of the trust can be the plaintiff. Or in case of extreme necessity, the Advocate General of the state can be the person who sets the law in motion. Now the question is, two things are to be contemplated when we deal with Section 92 CPC. Number one, can Section 92 CPC be invoked when there is no breach of trust? Can a plaintiff, in the capacity of a trustee, sue another trustee, or can the trustee be the plaintiff? Number 3, whether a relief which is sought for is in the nature of being granted by Section 7 of the Charitable and Religious Trust Act, which prevails over the other. These 3 questions arise for consideration when we speak of power of the courts regarding alienation. So when we speak of power of the courts to direct or permit the trustees, if so advised, or a direction to a party to compel a trustee to alienate the trust properties, what is the provision? That is the question. Section 92 1F is the provision which permits in specific terms that the court may order disposal or alienation of the trust properties. Per contra, Section 7 of the Charitable and Religious Trust Act 1920 does not contemplate such a power in specific terms. Section 7, of course, applies only for trustees. It speaks as follows. Section 7, powers of trustee to apply for directions. Save as hereinafter provided in this Act, any trustee of an express or constructive trust created or existing for public purpose of a charitable or religious nature, I'll come to religious nature a little bit later, may apply by petition to the court within the local limits of whose jurisdiction any substantial part of the subject matter of the trust is situate, court, for the opinion, advice, or direction of the court. I repeat, for the opinion, advice, or direction of the court on any question affecting the management or administration of the trust property. And the court shall give its opinion, advice, or direction as the case may be thereon. A rider is given in the proviso, provided that the court shall not be bound to give such an opinion, advice, or direction on any question which it considers to be a question not proper for summary disposal. So the pith and substance of Section 7 of the 1920 Act is very clear that it is only advisory in nature. It is not binding on the parties. It is not an appealable decree, and it is summary disposal in nature. So the inference that we are going to get from Section 7 is very clear that in case if the petitioner wants the court to adjudge and the matter demands a roving inquiry or it demands investigation of the dispute with elaborate trial, I'm sorry, Section 7 is not going to be handy for you. So the first and foremost takeaway message from Section 7 of the 1920 Act is that it is only an opinion and it is only an advisory jurisdiction. It is not binding on the parties. It is not going to be an appealable decree, and it will not be applied when it is not a fit case for summary disposal. Now only the interplay between Section 7 of the 1920 Act and Section 92 CPC comes into question. There are judgments, even by the Supreme Court, dealing with the scope of Section 7 as well as 92 CPC. See, the basic difference between Section 92 CPC and Section 7 of the 1920 Act is the person who is entitled to sue. So the first distinction that can be drawn, or the first point for consideration, is only a trustee can be a petitioner in a proceeding under Section 7 of the 1920 Act. It does not contemplate opinion by a third party, not even by the proposed purchase. Only a petitioner can be the trustee. The trustee can be the only petitioner in a proceeding under Section 7 of the 1920 Act. Per contra, Section 92 CPC does not contemplate the trust or trustees to be the plaintiff. Number one. Number two, Section 92 CPC presupposes an issue of a breach of trust. Section 7 does not contemplate such a situation. If a trustee wants an opinion, he can approach the court. So now, with these available parameters between the two provisions of law, we have to appreciate the niceties of the area in which these two provisions can be applied when it comes to the public charitable trust. Let me pause for a moment here. What happens when a religious trust comes into operation? Section 1 of the Trust Act is very particular. Indian Trust Act is very particular that a religious trust is outside the purport of the Indian Trust Act. As we all know, charitable and endowments is the subject matter of the concurrent list. And almost all the states in the country have respective state enactment regarding charitable and religious endowments. So, when religious trusts are concerned, the law that is going to be applicable invariably is only the state law. And Section 34 of the Tamil Nadu HRNC Act, which is akin to the HRNC Act in other states, is in the nature of compelling the sanction of the head of the department, being the commissioner of the Hindu Religious Charitable Endowment Administrative Department, to accord sanction when it comes to the question of either leasing out or alienating the property of the religious trust. So, whether it is a public trust or private trust, a religious trust needs the sanction of the HRNC department, where the law of the state is in force. Again, what happens if the trust deed contains a provision to dispose of the religious trust? I'm sorry to say that such a concession is not extended to religious trust. And if any property is sold that belongs to the religious trust without the sanction of the authorities, it is not going to help the purchases. So when we come to private or public religious trust, we have got a separate law in each and every state government. So the first question is public charitable trust. We have got two enactments, namely CPC as well as the Charitable and Religious Trust Act 1920. Regarding the public or private religious trust, we have got respective state enactment called HRNC laws, or in case of Muslims, it is Waqf. It is secular. And the third category now comes into question is the private charitable trust. Again, when we come to private trust, private religious trusts are outside the scope and ambit of Indian Trust Act 1882. So, for public charitable trust, we have got two enactments, namely CPC and the Charitable and Religious Trust Act 1920. For public or private religious trust, we have got respective HRNC or Waqf Act or the state government enactment, and the remainder is the private charitable trust. Here comes into operation the century-old enactment called the Indian Trust Act 1882. The Indian Trust Act 1882 applies only for private trust, as I said already. Now the question remains to be seen is, what is the provision governing the private trust in the Indian Trust Act? We all know by heart Section 34 of the Indian Trust Act, 34 to nearly 40, speaks of various powers of the. I don't want to decipher the sections or reproduce verbatim the provisions of law in the Indian Trust Act. We are mostly concerned with Section 34 of the Indian Trust Act. Section 34 of the Indian Trust Act is almost akin, similar to Section 7 of the 1920 Act. Again, Section 34 of the Indian Trust Act is only in the nature of an opinion or advice or direction being sought for by the trustees from the principal court of civil jurisdiction. Again, that is only an exercise of the advisory or consultative jurisdiction. It is not going to be an adversarial jurisdiction issue. It is not going to bind the parties, and it will not be a decree by the court of law competent. Again, it is only an opinion or direction or suggestion of the district court. So the question remains to be seen is very interesting. Here lies the point for consideration. Whether Section 7 of the 1920 Act and Section 34 of the Indian Trust Act, which are advisory in nature, which can be resorted to only when the inquiry is summary disposal, whether such a power to give directions or advice or opinion can be in the nature of permitting the trustees to alienate or encumber or dispose of trust properties. So this is what we are going to now discuss. There is an interplay of all these provisions when we come into power of the courts to give directions. So we'll just go to section 92 CPC that has got unambiguous, specific, clear terms that enables the court, when applied after an adversarial exercise of jurisdiction, to permit the trustee parties. I don't want to use the words trustees. It permits the parties to, or it permits the court to direct sale or alienation of the trust property. For the time being, we'll forget who can be the petitioner or plaintiff in section 92 CPC. So the provision is very clear that the court is all competent to issue a direction permitting alienation of a trust property. Okay. So regarding section 92 CPC, the powers are unfettered. It has got a power to appoint a trustee. Section 92 CPC will empower the court to remove a trustee, appoint a new trustee, direct it to produce accounts, direction to sell the property, and also direction to frame a scheme. Almost it is a self-contained code. Okay, no doubt at all. Okay, then what happens to section 7 of the 1920 Act? Once again, I told you already that it is only an advisory jurisdiction and it can be invoked only as a matter of summary disposal. So when a trustee under the 1920 Act seeks opinion of the court, and the court is of the firm view that it cannot be done because it pays only for the summary trial, whereas the dispute on hand requires investigation or a rowing inquiry, whether the district court can dismiss the OP, and in such case, what is the way out for the trustee who wants to dispose of the property of the public charitable trust? Because there may be occasion where section 92 CPC cannot be invoked. If we are on a premises that the trustee cannot invoke section 92 CPC seeking permission to sell the property, as we go by the wordings of CPC, or when there is no breach of trust that is presupposed by the Act. And if the trustee approaches the district court, and the district court finds that it is not a litigation for summary disposal, what is the way out? This question remains to be answered, number one. Number two, what is the test to be applied when a trust which is having a nomenclature of a private trust, but it is deemed to be a public religious trust which wants to dispose of the property? I may say that though I am a religious trust, I am a private trust, so I need not go to the commission of HRNC. So in such case, what is the test available to decide whether the trust is a public charitable trust or a public religious trust, or a private charitable trust or a private religious trust? Second question to be considered. Number three is, in case of a private charitable trust, where Section 92 CPC is not going to be applied. Section 34 of the HRNC Act or the HRNC Act or Waqf Act is not going to be applied. When the district court is of the opinion that I am not for a summary disposal in this matter, what is the way out for a trustee of the private charitable trust? These are all the questions which are going to be a subject matter of interplay between Section 92 CPC, Section 7 of the 1920 Act, respective provision of the Waqf Act or the HRNC Act of the state government, and the Section 34 of the Indian Trust. So before I'm going to just leave the point for discussion, let me just peep some of the judgments governing the field that will give an interesting introspection of the matter in dispute. The first and foremost judgment I want to rely upon is the judgment of the Supreme Court of India of the year 1965. The judgment is a landmark judgment. It's by a larger bench of 5 judges. Justice Gajendra Khatkar, Justice Vanchu, Justice Hidayatullah, Justice Shah, and Justice Sikri. 1966 AR Supreme Court 878. AR 1966 Supreme Court 878. In a case between Chairman Madappa versus M.N. Mahanta Devaru and others. Chairman Madappa versus M.N. Mahanta Devaru and others. 1966 AR Supreme Court 878. Here, the Supreme Court has discussed at length the power of the trustees to alienate the trust properties. Here, I mean only the public charitable trust, because what is discussed by the Supreme Court is Section 92 CPC. The Supreme Court, in its own way, in unequivocal terms, unambiguous terms, is of the specific view that a trustee of a public charitable trust has got every power to encumber or alienate or dispose of the trust properties if the trust deed so empowers him. And he is not depending upon, or he is not at the dictate of the court always. So the pith and substance of the judgment is very clear that it is not mandatory for a public charitable trust to seek the permission of the court under Section 92 CPC for a permission to sell the property as a condition precedent if the trust deed otherwise contains a result. Well and good, okay. But the question remains is, what happens to such an alienation? In the absence of the sanction of the court concerned, if a trustee or somebody goes for an alienation, is it not a voidable transaction? It can be questioned at a later point of time. If the court at the later point of time, when a suit is filed challenging the alienation without sanction of the court, if the court is of the opinion that the alienation was not done in the interest of the trust, or there is no procedure properly followed, what happens to the transaction? What is the title of the purchaser? Why should he suffer in the hands of a belated adjudication by the court? Anybody can challenge the alienation. So, I am just citing the judgment to say that in the presence of a recital permitting the trustees to dispose of a public charitable trust, to insist on the leave of the court is not required, but it is advisable in the interest of the title of the purchaser. This is the purpose of citing this judgment. Next question to be seen is whether the trust can be the plaintiff or trustees can be the plaintiff. This question came into consideration before the Supreme Court in the year 2020 in a case between Ghat Talab Kaulan Wala versus Gopal Das Challa Surti Das. 2020, volume 13, Supreme Court cases, page 50. Here, the Supreme Court is of the firm view that a trustee cannot be the plaintiff in an action under Section 92 CPC. So, the facts are different where the suit is filed against a Sevadar who claims to be a servant of the trust, but the court says a trustee cannot be the plaintiff in case of a public charitable trust. It's a very interesting judgment. you may go through for the purpose of better appreciation. Then there are questions that comes into consideration when Section 92 CPC can be invoked, whether Section 34 CPC can be applied for a public trust. Such a question came to be discussed by the Madhurai bench of Madras High Court in a case between K. Srinivasan and G. Kuppusamy Naidu Memorial Sport Trust. Reported in 2010, Volume 5, CTC, Current Tamil Nadu Cases, 438, where the Madhurai bench of Madras High Court, led by Justice A. Selvam, has discussed at length the various positions of law. And after discussing the nuances, the court has finally come to the conclusion that the Indian Trust Act 1882 cannot be applied to properties belong to a public trust, and even property of a private trust should not be sold by a private negotiation. Though the Trust Act permits a sale of the property by a private negotiation, the judgments of the courts of late have been of the nature that a private negotiation is discouraged. The court held that even property of a private trust should not be sold by private negotiation, and the same should be sold in public auction only after making wide publicity. And an application filed under Section 34 of the Indian Trust Act cannot be converted into Section 92 suit. This is the judgment of the Madhurai bench, an interesting one. Then, in case of trust which is secular in nature, for example, trusts which are running the hospitals or running the sports clubs or running the education institutions, whether they can invoke Section 92 CPC, the Madras High Court says yes, in a case between Arulmigu Mahalakshmi Temple versus M.S. Srinivasa Raghavan, reported in 2004, Volume 4, CTC 114. 2004, Volume 4, CTC 114. It's a very interesting judgment where the scope and ambit of Section 92 CPC is discussed at length. Then, an interplay between the HRNC legislation of the state and the Indian Trust Act comes into operation, where I'll share the citation, sir, to Mrs. Vikas, where the Supreme Court, led by the CJ of India, in the year 2020, has discussed the test to be followed to distinguish between a private religious trust and a public charitable trust. Because at times, there may be a trust, by its nomenclature of the deed, it may look like a private trust. By the objectives of the trust may be public in nature, or the beneficiaries are large public, they cannot be determined or they cannot be identified. In such a case, though the trust deed speaks the same to be a private trust, it is deemed to be a public trust in the eye of law. The test to decide such a distinction is given by the Supreme Court in a case reported in 2020, Volume 2, CTC, page 341. 2020, Volume 2, CTC, page 341, by the Supreme Court of India in a case between the idol of Sri Ranganatha Swami Temple Srirangam versus P.K. Toppular Chettiar. In para 15, the judgment is a compendium of all the law and rules in question. So these are all the very important judgments of an interplay between Section 92 CPC and the respective state legislation governing the HRNC legislation. Now, let us focus our attention to Section 7 of the Charitable and Religious Trust Act 1920. There are some judgments by the various high courts which are very interesting. I'm just giving only 4 judgments. All the 4 are in the nature of discussing the scope and ambit of Section 7 of the 1920 Act. First judgment is of Kerala High Court, Avosh Devar versus Chumar, reported in 1957 to Kerala CK, page 11. I'll give the citation to Chatrat later, where in para 6, the Kerala High Court has discussed very clearly the scope and ambit of Section 7 of the Act. The cumulative effect of the judgment is that the court will refuse to consider the matter and give an opinion or advice or direction if the matter involves a roving inquiry and if it is not capable of disposed of as a summary disposal. So the take-home message is very clear that Section 7 of the 1920 Act cannot be applied when the court wants a roving inquiry, and it cannot be a matter for adjudication by summary disposal. In a case between Dr. Mansingh and others, reported in AIR 1974, Delhi High Court 228, the scope and ambit of Section 7 of the 1928 has been discussed at length in para 17 to 19, AIR 1974, Delhi 228, where the court has very clearly held that an application can be made under Section 7 of the 1920 Act, and the jurisdiction of the district judge is only advisory. It is not binding on the parties. This is also an important judgment of the Delhi High Court. When we come to Calcutta High Court, it is there in AIR 1982 Calcutta, page 14, in a case between Neelima Ghosh and another, versus Prakriti Bhushan. And in para 5, the Calcutta High Court has discussed the nuances of Section 7 of the 1920 Act, pitted against Section 34 of the Indian Trust Act. I would rather say that this judgment is a compendium on Section 34 of the Indian Trust Act. The Calcutta High Court discusses the ingredients of the section and what is the role of the district court and how an application can be adjudged when it is filed under Section 34 of the Trust Act. And it is also has got some direction regarding Section 7 of the 1920 Act. Next judgment is by the Madras High Court, reported in 1999, Volume 7, Madras CK, that is Court Kacheri, page 142. It is called Sennimalai Swami Maram Trust, Palani versus so-and-so. Here also, the Madras High Court has discussed at length the scope and ambit of Section 7 of the 1920 Act, and finally holds that it is only advisory jurisdiction. It cannot be applied when it requires a detailed roving inquiry. Then we'll have to go to Section 34 of the Indian Trust Act, which is very much important for the discussion on hand. There are umpteen number of judgments by various high courts across the country permitting alienation by the trustees at the behest of the district court. Of late, the law has been changed by the courts in a specific direction. The first judgment I want to cite is that of the Madras High Court, reported in 2003, Volume 2, Madras Law Journal, page 290, in a case called Raghupati and others, where the Madras High Court has discussed at length the scope and ambit of Section 34 of the Indian Trust Act, and also has got a rider that in the event of permission being granted for sale, then the district court has to ensure a proper process for securing the highest possible sale consideration by directing the trustees to give proper advertisement and confirmation of sale only by the order of the court. And the court decides very clearly that a district court under Section 34 of the Indian Trust Act is all competent to give a direction permitting the trustees to dispose of the trust property. This is where I want to highlight the judgments. The second judgment of Madras High Court, where such a power is conferred on the district court under Section 34, is reported in 1989, Volume 1, Law Weekly, page 388. Satyamurthy versus Rukmani. Here also, the Madras High Court has categorically held that a district court who is approached under Section 34 is all competent to issue such a direction, permitting the trustees to dispose of or alienate income of the trust property if all the tests are satisfied. But there is a case where the Madras High Court has refused to exercise the jurisdiction when it has got a doubt whether it is a public charitable trust or it has got some private trust. When a public charitable trust is sought to be a petitioner in a petition under Section 34 Indian Trust Act, the Madras High Court says no. That is a case reported in Manu, Tamil Nadu, 3161 of the year 2020, in a case called Swami Dayananda Saraswati Memorial Trust, where the Supreme Madras High Court held that if the trust is not a charitable private trust, and if it is a trust which has got a public charitable trust, Section 34 of the Indian Trust Act should not be invoked. Then, when the matter has gone to the Supreme Court in a case concerning the Nizam of Hyderabad, in the year 2000, the Supreme Court has categorically held that Section 34 of the Indian Trust Act 1882 cannot be equated to 92 CPC by any stretch of imagination because they operate on a two different track. It's a case law reported in year 2000, volume 4 Supreme Court cases, page 179, in a case called Trustees of HEH, the Nizam Pilgrimage Money Trust, Hyderabad, versus Commissioner of Income Tax, Andhra Pradesh, where in para 10, the Supreme Court has categorically held that a court sitting under Section 34 of the Indian Trust Act cannot be equated to a court under Section 92 CPC. It speaks of the interplay of the sections. Again, a similar order has been passed by the Supreme Court in a case between official trustee West Bengal and Sachindranath Chatterjee. It's one of the famous cases where it is reported in AR 1969 Supreme Court 823. AR 1969 Supreme Court 823, where the Supreme Court held that the power of the court under Section 34 of the Indian Trust Act is very much limited. It cannot be equated to that of the court in Section 92 CPC. And one more case by the Supreme Court in the year 2006 cautions the district court to be very careful while exercising jurisdiction under Section 34 Trust Act by stating that if the trust is having a semblance of a religious nature, Section 34 of the Indian Trust Act should not be applied. It should be left to the state law of the HRNCE concerned. It is a case between Joint Commissioner HRNCE versus Jayaraman and others, reported in year 2006, volume 1, Supreme Court cases, page 257. In para 6, the Supreme Court has discussed the interplay between the provisions of the Indian Trust Act vis-a-vis the Tamil Nadu HRNC Act. The Supreme Court is very clear that when there is a semblance of religious trust coming into picture, the district court should not invoke Section 34 of the Indian Trust Act 1882. And whether Section 34 of the Indian Trust Act can be invoked to modify the terms of the scheme, that question came into consideration before the Madras High Court. The Madras High Court said no, because Section 34 is only advisory in nature, whereas the modification of the scheme involves the question of your roving inquiry and hearing the other side. So such an advisory jurisdiction and summary disposal cannot be extended to a relief of what is called modification of a scheme terms, and it's in a case called Periya Pallivasal versus so-and-so, in a reported case called 1997, volume 1, current Tamil Nadu cases, 576, where the Madras High Court has very clearly held that Section 34 of the Indian Trust Act cannot be applied to all cases where the courts cannot exercise its jurisdiction. Now, we have four provisions of law. Section 92 CPC, especially Section 92 1F, regarding power to alienate the trust properties. Then Section 7 of the 1920 Act, which is advisory jurisdiction, summary disposal. It is exercisable only by the trustees. It is in the form of opinion or advice or direction. And number 3 is respective state law of Waqf as well as central law of Waqf or HRNC Act, where the power is given to give sanction for alienation of the private or public religious trust. Then Section 34 of the Indian Trust Act, which is going to be applied for private trust of charitable nature. Now we have got the 4 acts going to be applied. I have posed a question in the beginning that whether Section 92 CPC can be invoked in the absence of breach of trust. Who can invoke Section 92 CPC? Whether Section 7 of the 1920 Act can be invoked when there is scope for an adversarial jurisdiction and the summary disposal is not possible. Whether Section 34 Trust Act can be extended to a public charitable trust. Whether the scope of the district judge sitting in Section 34 Indian Trust Act is only advisory, and in case of any adversarial jurisdiction or a roving inquiry, whether Section 34 Trust Act can be invoked by the district judge. These are all the questions to be taken into consideration. I will just take you to 4 judgments, which will give you a rough idea about what the law is about. One judgment of the Madras High Court, reported in 2022, Volume 1, Law Weekly 406, in a case between Kanchi Charity Trust, has held that Section 34 of the Indian Trust Act can be applied to a trustee of a public charitable trust. The reasoning given by the Madras High Court, led by a single judge, is that Section 92 CPC cannot be invoked in the absence of breach of trust. So, instead of applying Section 7 of the 1920 Act, the Madras High Court, led by a single judge, has held that for a public charitable trust, in the absence of breach of trust, Section 34 of the Indian Trust Act can be applied. This came to be suspected to be an incorrect judgment by subsequent benches, and the matter was placed before the Division Bench of Madras High Court on reference. The Division Bench of Madras High Court has answered the question in the negative in a case law between ARR Charitable Trust versus Amrita Vishwa Vidyapeetham, in a case reported in 2024, Volume 1, CTC, page 316. It's a beautiful judgment dealing with the scope and ambit of Section 92 CPC, Section 34 of the Indian Trust Act, and Section 7 of the 1920 Act. But, of course, the point for reference is this. The Kanchi Trust Act judgment is questioned. Whether a public charitable trust can take umbrage under the provisions of the Indian Trust Act while seeking permission to dispose of trust properties under the guise of lack of or want of breach of trust. This point is answered in the negative by the Division Bench of Madras High Court, stating that a public charitable trust can never invoke the provisions of the Indian Trust Act. Section 34 is not available. The only proviso, I think the only law applicable to public charitable trust is Section 92 CPC, and Section 92 1F is the only provision. By no stretch of imagination, the Private Trust Act, that is Indian Trust Act 1882, Section 34, can never be invoked by a public charitable trust. This is the judgment of the Madras High Court sitting in the Division Bench. Incidentally, the Division Bench is of the view that as per the judgments of the Supreme Court of India and lot other judgments of various high courts, the Division Bench traces the march of law elaborately by referring more than 12 judgments. It states that both Section 7 of the 1920 Act and Section 34 of the 1882 Act are advisory in nature. They are capable of dealing only with summary disposal disputes. They cannot be invoked for the purpose of getting a roving inquiry. And these provisions cannot be invoked when the scope of Section 7 and Section 34 retrospectively cannot be applied into. So now an interesting question arises into consideration is, what happens when there is no breach of trust and yet the trustees approach the civil court under Section 92 CPC? This bench in the year 2024, in a case reported in 2024, 1 CTC page 316, are the firm view that even in the absence of a breach of trust, Section 92 CPC can be invoked. Because Section 92 CPC has got two clauses. When one limb is absent, the second limb can be applied. And it is not the only criteria in case of breach of trust. Section 92 CPC is to be applied. The court's jurisdiction can be invoked when one of the parties or any of the parties wants the interference of the district court for the proper management and administration of the trust. So this judgment has answered the question that Section 34 of the Indian Trust Act cannot be applied to a public charitable trust, and Section 34 of the Indian Trust Act and Section 7 of the 1920 Act not always capable of being invoked when a roving inquiry is impossible and a summary disposal is only contemplated. This judgment has not, however, taken into account the previous judgment of the coordinate bench of the Madras High Court. It was not placed before the bench by the advocates concerned. Judgment of the division bench of Madras High Court is reported in 2018 volume 3 CTC page 801. 2018 volume 3 CTC page 801. It's a case of a dispute governing the Waqf or Dargah, Nagur Dargah. Managing trustee represented by the board of trustees Nagur Dargah versus Haja Nuruddin Sahib is the cause title, where in para 23, the coordinate bench, division bench of Madras High Court in the year 2018 has categorically held that section 92 CPC is attracted only when there is a breach of trust. And in the absence of a breach of trust, section 92 CPC cannot be invoked. So these two judgments of the coordinate bench has to be reconciled either by difference of the facts of the case or by the scope of the ambit of the point for adjudication. Now, the simple question that remains to be answered is this. A district court is approached for a direction or advice or opinion permitting the trustees to dispose of the trust property, or an advocate is approached for an opinion to sell the property of a trust. What is to be done? See, in case of an opinion sought for from an advocate by the proposed purchaser or a trustee as to whether leave of the court is compulsory to go for an alienation of trust property, I would say yes, because though the recital of the trustee may empower the trustees to alienate the property, though the Supreme Court in a bench led by the 5 judges bench by Justice Wangchu permits such alienation in case if the trustee authorizes the trustees, it is challengeable in the court of law. Any person who is aggrieved, it may be a person who is a beneficiary or a person who is interested, they may challenge the alienation, subject to, for example, law of limitation. So the purchaser may not be happy if you give an opinion stating that you proceed and later it is challenged. So I would suggest that always it is better to go for opinion of the court. In such case, in case of a religious trust, well and good section, so-and-so section of the HRNC Act or Waqf Act is going to apply, where there is no lacuna at all. The doubt remains only in a public charitable trust. In the absence of breach of trust, whether to invoke section 92 CPC or section 7 of the 1920 Act. 92 CPC has got omnipotent powers, but section 7 is only a limited advisory powers and it is not binding, it is only a summary disposal. Similarly, when a private charitable trust is being the subject matter, section 34, again it is only an opinion, advisory or direction, and it is not a binding one, and it is only a matter of summary disposal. In case, if the district judge is of the opinion that it is not the occasion where I want to exercise the power of the court under section 34 of the 1982 Act or section 7 of the 1920 Act, what is the way out? I got only one judgment of Madras High Court led by a single judge called Justice K. Sampath, reported in a case between A. Changayya and others, reported in 1997, volume 3, Law Weekly, 537. This judgment is relied upon by the division bench of Madras High Court in the year 2024 AR case, where the Madras High Court is of the opinion that when section 34 CPC cannot be invoked because it requires a roving inquiry or an adversarial jurisdiction or a detailed investigation, and it is not a matter for a summary disposal, the Madras High Court says, please refer the parties to go to a civil court and file a suit under Order 721 CPC. So, the interplay is going to give a picture like this. In case of a private or a public religious trust, we have got respective religious acts. There is no escape route at all. For example, in case of Hindus in Tamil Nadu, Karnataka, Andhra, we have got the HRNC. All the states have got HRNC Act. or the Waqf Act. The respective tribunal or the commissioner will take care. In case of public charitable trust, we have to find an equilibrium and decide whether a trustee can be the plaintiff or whether a trust can be the plaintiff. And if you are satisfied that yes, it is possible, it is safer to move the district court or sub-court, as the case may be, under section 92 of CPC, get the opinion of the court. If you are of the opinion that section 92 CPC is only applicable for persons other than trustees, you will have to move district court under section 7 of the 1920 Act. If the court is of the opinion that I cannot use this jurisdiction because of my handicap, because the inquiry is summary or it requires roving inquiry, the court may direct you to move the civil court under the regular jurisdiction, Order 7 Rule 1. In case of a private trust, which is charitable in nature, if Section 34 Trust Act is invoked, well and good, the court has got power to direct alienation. In case if the district court is of the opinion that it requires a roving inquiry and it is not a matter for its summary disposal or some adversarial interest is invited, again, the district court has to direct the parties to move the civil court as per the judgment of the Madras Court in 1997, 3 Law Weekly, page 537. But again, 2 points are yet debatable. I am not in a position to say that this is the conclusive law of the land. Whether section 92 CPC can be invoked by the trustees as the plaintiff, whether section 92 CPC can be invoked by any parties in the absence of breach of trust, whether section 7 of the 1920 Act and section 34 of the Indian Trust Act can be refused to be invoked for the simple reason that it is only advisory in nature. So these questions are the questions which are to be answered by the advocates or the judicial officers by applying their rich experience and knowledge and depending upon the facts and circumstances of each and every case concerned before them. This is the interplay of the provisions. With this, I close the elaborations. Thank you, Vikas, for the opportunity.
Thank you, Mr. Raghavan. As we had started off the session by saying that interplay is not easy, but the way you have shared the knowledge, taking us into a deeper dive, it looked actually simply simple, coupled with the fact that I can be sure that those who are facing these issues, you are giving them a thought to ponder upon, and secondly, also having a deeper knowledge and deeper dive of the subject. Thank you for sharing your knowledge once again. Thank you.
Thank you. I will share the citation. You can share with the participants later.
We will share it on the website.